Welcome to Books for Beneficiaries. My name is Pete Williams, the host of the program on which we talk about the needs of beneficiaries. In estate planning matters, it is the estate owner that takes center stage, and that, of course, is appropriate. It is, after all, their wealth. However, the beneficiary sometimes is left in the dark as to the process. They have needs and questions. They want to ensure that they have their proper inheritance. So I am hopeful that this series will shed some light and give them some information that will help them. I call this series Books for Beneficiaries. So stay tuned for the next chapter and check back for more to come. Today, I want to talk about trusts, which is a huge subject matter and is going to take several episodes. And in fact, today, I'm going to talk about the Revocable Living Trust, which is a standard estate planning tool that is used in many, many jurisdictions to pass on assets from one generation to the next. And actually, it could be used to pass on to several generations, but it is the standard probate avoidance technique that is used today. And it itself will take many episodes to talk about. And then we'll talk about other trusts. So what are they? How do they work? And why do they even matter? A trust, any trust, is an entity. It is very much like in forming a corporation or an LLC. There are certain parties involved, there are certain rights to parties, and there are certain duties that are owed. In a trust, any kind of trust, is a three-party transaction where you have somebody who created the trust. Usually I use the word settlor. The other term sometimes is trustor or creator, and I'll use those interchangeably. But it's the person's assets that are put up into the trust. And then we have a trustee, and that is the person who's responsible for handling the trust assets and managing those assets held in the trust and distributing those assets. And then there's the beneficiary. And that's the person who benefits from the trust, to whom is owed a fiduciary duty by the trustee. The trustee has a responsibility to treat those assets for the best interest of the beneficiary. And that's why we're going to focus on this discussion about trust from the viewpoint of the beneficiary. As I mentioned, this is a huge subject. And there's many different types of trust. There's Revocable Living Trust, there's irrevocable lifetime trusts, and there what I mean is we can create a non-revocable, non-changeable trust during our lifetimes. And then there are testamentary trusts, which are typically irrevocable, non-revocable trusts that are created at death. And then there's this whole alphabet soup of types of trusts that attorneys have created in order to accomplish some goal, some tax goal, some distribution goal, etc. I'll just name a few here. Q-tips, Q-dots, ABC Trust, ILETs, GRATs, GRUTs, Q-PERTs, Charitable Remainder Trust, CRTs, Charitable Lead Trust, CLTs, GST, IDGTs, and the RLT. And I'm going to focus on that last one, the Revocable Living Trust right now, because it, as I mentioned, it's at the core of many estate plans today. So you as a beneficiary have to understand the terms. If you are a beneficiary of a Revocable Living Trust, have to understand when your rights accrue and the duties that are owed to you under that trust. So first of all, just a generalization about what a revocable trust is. It is created during life, and ergo the living part of the Revocable Living Trust, created by a settlor with their assets, and it is revocable and amendable. And we're going to stress that later on because as beneficiary, you need to know that during the lifetime of the settlor, the terms of the trust can be changed. After all, the settlor's assets, and they can do whatever they want with their trust assets. And while living, the Revocable Living Trust is set up for the benefit of the settlors, the creators of the trust. So what happens is that the settlor creates a trust document, it can run anywhere from 5 pages to 32 pages, and even into the 60 and 70 pages if the attorney goes crazy with definitional things. The settlor creates a trust in which they are also the beneficiaries, and the settlor is often the trustee. So the person creating the trust, the revocable living trust, during life is all three: settlor, trustee, and beneficiary. So I set up a revocable living trust for myself. I put assets into it. I fund the trust with my estate. And while I'm alive and well, I am the settlor, the trustee of my own trust, and the beneficiary of my own trust. Why do we have revocable living trusts? Well, typically, it's a transferring assets that avoids the probate process. And there are many ways to avoid probate, but it's probably the most flexible and most comprehensive way to avoid probate. There is continuity at incapacity, so that if I set up my trust and I become incapacitated, I no longer can act as trustee. I will always be the settlor, and then while I'm alive, I'm the beneficiary. But if I'm incapacitated, there's a trustee problem. So in my trust, I name a successor trustee. Hey, if I ever become incapacitated or die, then I name Joe as my successor trustee to handle my assets. While I'm alive and incapacitated, those assets are for my benefit. A third reason for setting up a trust is for privacy. And that goes along with probate avoidance. When you go through probate, generally you're creating a public record. And when you have a trust, it does not create that public record. There's no need to go through the court system. So there's no court records in passing on assets through a revocable living trust. And also, the revocable living trust helps with situations where there are multi-state assets. So I have assets in California and Tennessee and New York and Georgia. And the revocable living trust can help avoid probates in all those different states. And mind you, all states have different rules, but in most states, jurisdictions, you can avoid probate in those states if you register as a revocable living trust. So live, die, become incapacitated. The revocable living trust handles that situations through its terms, and everything is defined and spelled out in who the successor trustee is, who the beneficiaries are, what circumstances are triggered to pay out funds to either the settlor or beneficiaries. We mentioned that that the trust can be amended or changed, and when it's completely redone, it's called a restatement of trust. And a change in the trust document affects all assets, and this is kind of key. This is administratively, this is very important, because when I have a trust, Pete Williams Trust dated January 1st, 2026, and I pull in my assets in it, which could be brokerage accounts, it could be real estate, it could be rental income property, it could be personal property. So when I want to make a change, for instance, in beneficiary designations, I don't have to change the beneficiary on each asset. If the asset is held in trust, then my change in the trust document, whether it be a complete restatement or an amendment, changes the handling of all assets in the trust. So there's some great administrative advantages to a revocable living trust over other forms, such as pay on death accounts and joint tenancy and that sort of thing. From a tax point of view, the revocable living trust is a pass-through entity. A revocable living trust simply initially uses the settlor's Social Security number to report income and capital gains. So everything is taxed to the settlor during life. When it becomes irrevocable, generally upon death of the settlor, then it becomes its own entity and it needs its own separate tax ID number. And then it has its own tax returns at that point. Now, here's an important thing that I want to drive home to you beneficiaries out there. You may have been told by a parent or a grandparent or whoever might name you as beneficiary in a trust and shown you a document that says, hey, you're going to get $1 million from my trust. Understand that if you've seen a document, either maybe someone shown it to you or maybe you inadvertently come across it, understand that that trust can be changed during life. Remember, the assets in that trust belong to the settlor creator of that trust, and they can do whatever they want. And these stories come up every day wherein a settlor has cut out family members in a trust. And sometimes these cases are sad, and sometimes they make perfect sense. But just understand, if you see an original version of a trust, don't take that as gospel. It may have changed. When a settlor becomes incapacitated, and that is, now I'm talking about mental incapacity here, not just physical incapacity. They are unable to change the trust during that period. And if changes were made when somebody did not have mental capacity to make a change, that may give you as a beneficiary the right to contest the change. But on death, no more changes. It becomes irrevocable. Here's some language that is typical in a trust agreement, and I hope you all can see this. But it's the trust agreement of the Doe Family Trust. And first of all, let me apologize. I am in a community property state, and there's only 8 of us. I think there's like 8.5 jurisdictions that have community property. In community property states, we typically create joint trusts where a husband and wife create a single trust, and they put in assets and they identify what is community and what is separate. And so here we have John and Jane Doe, husband and wife, who are the settlors of the trust, and they transfer to themselves as trustees of the Doe Family Trust. And it has a date. You don't see this very often, but in theory, somebody or a couple could have several revocable living trusts that hold different assets in different terms. It's very unusual, but it's possible. So the date of the trust is important to define which trust and which assets belong to that trust. So here's some more introductory statements that are included in a revocable living trust. The settlors, while living, may amend or revoke. We've talked about that. It may talk about the purpose of the trust, and it may be something very generic, like the purpose of this trust is to distribute my assets upon death and to have my assets handled upon incapacity. And it will state that these assets that are in this trust are mine. The settler says, "Hey, these nothing's changed as to my control over these assets." So, what are the beneficiary's rights? Well, they're very limited during life. The assets belong to the settlor. They are for the benefit of the settlor, even if the settlor is incapacitated. So during the lifetime of the settlors, it's theirs. They just treat it. They pay bills. They make investments. They buy and sell homes. They do whatever they want with their assets within that revocable living trust entity. Now, one thing to follow up on, even though the assets are for the benefit of the settlors while they're living, and I have to be very careful here because the beneficiary has no rights. I mean, this is the settlor's own business, but the beneficiaries do want to be mindful of some undue influence. I just read an article, I think it was yesterday, that a nursing home turned out to be the beneficiary of an estate, of a trust. When the parent went into the nursing home, everything was for the beneficiary of the children. Something happened in the nursing home, and it turned out that when he died, the assets were to the beneficiary of the nursing home. Now, that's probably a very unusual circumstance because generally nursing homes have very strict rules now that don't allow that to happen, or that give notice that that's happening. So after death, the beneficiary is going to have to prove undue influence if they want to contest the changes in the trust. Related to that are fraud. So as our parents age, they sometimes are more subject to fraud. I don't know how many spam calls I get a day, but I get a lot. And I would guess a lot of those might be fraudulent calls trying to get me to give up my Social Security number, my banking information. So even though the settlor is alive and well, the beneficiary should if it is, certainly if it's a child, be caring for a parent so that the parent understands that and knows what they are doing where they might be subject to fraud. And then there's the pure case of incapacity where there's no mental capacity to sign legal documents. So you might, during life, even though you have no rights in those assets yet, you might make note of when there are periods of mental incapacity, and that often happens shortly before death. So that's a brief introduction to revocable living trusts, and there's a lot more to talk about. But during life, the assets are for the settlor. Upon incapacity, in that trust document, the settlor has named a successor trustee to handle the assets for their benefit while they're alive. And then upon death, handles distribution to beneficiaries in accordance with the trust document. So, with that brief introduction, we're going to get into the nuts and bolts of revocable living trust, and ultimately we're going to talk about how assets come out to you as a beneficiary. So I want to thank you, and once again, the information provided here is not intended as legal, financial, or tax advice. If you need that kind of advice, you should seek out your own expert who knows your specific circumstances so they can give you appropriate advice. So thank you very much. And I look forward to the next episode where I will continue to talk about revocable living trusts. And beyond that, we will talk about other kinds of trusts. Thank you.